My name is Jim Sellers. I'm a plaintiff's trial attorney who practices in Oregon, Washington, and I'm going to try and answer some questions for you that I have clients ask me for the maximum amount of money that ultimately we can get the insurance company to agree to settle to. Now, my practice is I never submit a sum of money in settlement of the claim unless my patient or my client has agreed to that in advance, or unless they authorize me to accept an offer made by the insurance company in settlement of the claim. And we work to try and maximize the amount of money that the insurance company will voluntarily pay. And normally we get them to an amount where they'll say that's the most they're ever voluntarily willing to pay. When that happens, the client has a choice. One, they can have us settle for that amount, or two, they can have us file a lawsuit with the idea of going to a trial by jury to recover money against the party that hurt them, which their insurance company would be required to pay. And generally, that's how claims are processed. Most cases don't result in the filing of a lawsuit. Those cases are settled through negotiation. Other cases result in the filing of a lawsuit, and most of them never go to trial and result in a negotiated settlement, even though we've had to file suit. But that's the way in which claims are processed. If you have any questions, you can call me if you're interested in having me look at your case, and I'll be glad to talk to you. Nice talking to you this afternoon. Hi, I'm Jim Sellers. I'm a plaintiff's trial attorney who practices in Oregon and Washington. I'm going to try and give you some guidance about what becomes involved if negotiations for a settlement of your claim fail and it becomes necessary to file a lawsuit. When a lawsuit's filed, what happens pending the filing of the lawsuit in a trial by a jury is governed by local court rules that vary from state to state. I'm licensed in Oregon and Washington, and the rules in both states are somewhat different. In Oregon, I'm going to discuss that first because it's the simplest to understand. When the lawsuit is filed, generally it's going to go to trial. If it's tried, not settled before that, it's going to be tried at 1 year from when the case was filed. And in that 1 year, there's some things that happen. The primary thing that happens is the plaintiff and the defendant exchange requests for documents that either one of them may hold, which they have to produce. And your attorney generally puts those documents together, but sometimes the attorney requires the client's help to put those together. And those documents consist primarily of medical records and bills, both for the treatment of the injuries sustained by the client on the case that the attorney is representing the client on, and prior injuries or conditions affecting the part of the body injured in the claim the attorney is representing the client on. And it's necessary to put all those things together. There's other things that are requested too, like vehicle estimates in auto cases for damages and things like that. So once those items are exchanged, the other major things that happen are that the client is expected to attend a deposition conducted by the defense attorney, and the client may be required to attend a medical exam by a physician bought and paid for by the insurance company. The insurance companies like to refer to those examinations as independent medical examinations, but they're not independent. The doctors that conduct those examinations overwhelmingly understand they're conducting them for an insurance company, and that is reflected in the opinions